Thank you, Mr Batchelor. Mr Bourman.
Thank you, Acting President. Acting President, I might just make a comment on Mr Batchelor's contribution then. I actually completely agree. The ability of the new, I'm not sure what its name is going to be at the moment, the ability of the new authority or department or whatever, it must prioritise enforcement. Yes, it should be able to promote proper sustainable hunting, fishing and so on, but in the end, for better or for worse, their job is also to enforce what goes on in the various arenas. And what must not be lost in the chatter here is this isn't just about duck hunting. There's all sorts of hunting that goes on in this state, and it's very important. The other comment I'll make is apparently no one else other than Mr Batchelor wanted to go first, so there's a lot of jockeying for position to see what everyone else has got to say. Well, here it is. I'm going to have at it. The Shooters, Fishers and Farmers Party welcomes and supports this bill and congratulates the government on taking this important step through the establishment of what is currently Outdoor Recreation Victoria. In particular, the Premier, the current Minister and the former Minister responsible for outdoor recreation deserve credit for backing and progressing this reform and seeing it through this chamber. We, the Shooters, Fishers and Farmers Party of Victoria, are the only political party whose reason for existing is to support recreational shooters, hunters and fishers. We do what it says on the wrapper. To be fair, Animal Justice Party does too. They are open and consistent in opposing hunting, fishing and the sustainable use of animals. We know where they stand, we know where we stand, we know where the Premier and the government stand. What remains genuinely difficult to work out is where the Liberal National Party stands, and I'll get to this. We have before us two shadow ministers who would carry responsibility for outdoor recreation in Victoria under an alternative government, and they appear to be saying fundamentally contradictory things about hunting. Presumably one reflects coalition policy and one doesn't. When this matter goes to a division, we may finally get an answer. Either members vote differently or they vote together, and Hansard records that someone has spent this debate saying one thing and voting another. And when I say debate, I don't necessarily mean the debate in the House. Now, the Shooters, Fishers and Farmers Party may move amendments, not because we think this bill is deficient, but because we think a good bill can be made better. Now, there has been some movement behind the scenes with other amendments, so that's why I say may. We'll see how that works out. Today, I want to do three things: address some of the myths and distortions that have already emerged about outdoor recreation in Victoria, and talk briefly about the pathway that got us here, and to speak to the opportunity this bill creates. So much has been said about this bill, including reporting by the national broadcaster that, in my view, omitted important context. The ABC implied that the GMA had exposed the identity of a protester. What readers were not told was that the court had already released the material and another outlet had already published the man's name, town and unobscured image. The GMA did neither. It obscured the face and did not identify the individual. Yet, we have a member of this House describing that as doxing. That is curious, given that the same member previously used parliamentary privilege in this chamber to publicly identify a GMA staff member and later chose to redact that person's identity when posting the footage online. Yet all the details of that staff member remain on Hansard and are available to anyone on the internet. Members are entitled to strong views, but they should apply the same standards to public servants as they demand of others. The article also relied on selective excerpts from a clandestine recording made of remarks by a GMA officer and used them to imply bias. The proposition that regulators should not have subject matter expertise, including familiarity with hunting, is difficult to take seriously. Some GMA officers hunt and some do not. What matters is that they fairly enforce the law. So should we preclude traffic police from driving? Should we preclude the cyber criminal investigators from having computers? The Civil Aviation Authority, CASA, promotes involvement in aviation, yet they enforce the rules. The real problem here is not about regulation or anything, it's about people don't like hunting. The data does not support the narrative presented anyway. Across the 2025 and 2026 duck seasons, approximately 93.5% of GMA compliance action related to hunting offences and only 6.5% to public safety offences, protester offences. That is not evidence of a regulator protecting hunters. It is evidence of a regulator regulating hunters. The article also relied on selective excerpts of a clandestine recording of remarks made by the GMA officer about letting children breaking the law. That is incorrect. It gets a bit complex here. The comments were related to a narrow public safety restrictions only applying at specified hunting times and areas, not a general prohibition on unlicensed people being present. Section 58C of the Wildlife Act specifies that a person must not enter on or remain in any specified hunting area, and so on, and there's a fairly hefty punishment of 60 penalty units. Pretty straightforward. But the article ignored that the Victorian criminal responsibility laws apply. Children under 12 cannot commit an offence. Removing a child from an area rather than issuing a penalty that cannot be lawfully imposed is not selective enforcement, it is implying the law as made by this parliament. I note those baying about how bad this situation is are the very same people who supported raising the age of responsibility from 10 to 12. Well, here you are. In case you're wondering, I voted against that change. The ABC article also cited the 2017 Pegasus review as evidence of systemic failure within the GMA and incorrectly stated it was commissioned by the government. It was not. The review was commissioned by the GMA board following the Marshes incident, a regulator voluntarily submitting itself to scrutiny. The article also admitted what happened next. All the accepted recommendations were implemented and substantial reform followed. The article then relied heavily on George Buckhorn and created his criticisms as authoritative evidence of the current culture within the GMA. Mr Buckhorn is entitled to his views, but the readers deserve context. The context is that Mr Buckhorn was the head of GMA compliance at the time the problems were occurring. During the parliamentary inquiry into native bird hunting, committee members questioned why compliance and prosecution outcomes were lower during Mr Buckhorn's own tenure rather than before and after it. He disputed that proposition, but the data does not lie. The inquiry also established that the ministerial engagement he relied on had been facilitated through the Animal Justice Party. Hardly an unbiased witness. Imagine the carry-on if I had have done a similar thing. It would all be about the fearsome gun lobby. More broadly, Mr Buckhorn's credibility has been publicly tested before. During IBAC's Operation Gloucester, counsel assisting described aspects of his evidence as the height of ridiculousness, before proceedings were adjourned after Mr Buckhorn did not return a break. Now, I invite anyone who wants to look up what Operation Gloucester was about. I actually have a personal connection to that. But anyway, criticism is easy, reform is harder. The leadership that followed Mr Buckhorn did the hard work of cleaning up his mess, implementing the Pegasus recommendations and building a stronger regulator. The article also relied on commentary from former GMA board member Dr Bronwyn Orr, suggesting regulation and promotion cannot comfortably sit together. I disagree. Regulators should be judged on governance, transparency, decisions and outcomes. But if Dr Orr genuinely believes promotion and regulation are incompatible, perhaps the RSPCA can explain which functions it tends to stop performing. More fundamentally, I don't think the objection here is governance. If this bill removed the hunting promotion from Outdoor Recreation Victoria tomorrow and instead created a separate statutory authority solely responsible for promoting the lawful, ethical and sustainable hunting, I do not believe those critics would suddenly support this model. The objection is not a promotion by a regulator, it is the promotion of hunting itself. If that is your political position, then it should be argued openly. Now, the GMA did not have an easy start. It was created to give hunting specialist independent regulation, but its early years were difficult and the Marshes incidents represented its greatest test. To its and former Minister Pulford's credit, the response was not abolition, it was reform. Governance improved, compliance expanded, education increased, and the organisation matured into the independent regulator it was intended to become. The Victorian Fisheries Authority took a different path, but proved the value of specialist agencies focused on participation and delivery. Victoria has developed a distinctive model. Recreational participants is recognised as the primary use of the resource, while commercial activity, though important, is secondary. That reflects the broader idea. Our natural resources should create environmental, economic and social value for the greatest possible number of Victorians, not just the cultural elites of inside the goat's cheese curtain. This is why the Ministry for Outdoor Recreation, and now Outdoor Recreation, matter, or whatever it turns out to be. Hunting and fishing are no longer square pegs awkwardly fitted into environment and agriculture portfolios. They are recognised as important recreational activities and critical economic drivers, particularly in regional communities like Eastern Victoria. This bill is an institutional reform bill. It does not change who can hunt or fish or where they can do it. It establishes an organisation whose job is to regulate, promote participation and improve access. For me, the most exciting part is the Land Access Panel. Access is not just permission, it is roads, signs, facilities, information and confidence. Done properly, this could quietly become one of the most significant land access reforms in decades. We may move amendments to the bill, not because I oppose the direction of the bill, obviously, because it is a once-in-a-generation reform and getting the settings right now matters. So I'm going to conclude. This bill recognises something many Victorians already understand. Hunting, fishing and outdoor recreation, and commercial fishing of course, matter. Today I've spoken about the facts. Because criticism should be fair, the history because institutions can improve, and the future because outdoor recreation in Victoria can be better than what became before it. The direction of this bill is right. The Shooters, Fishers and Farmers Party support this bill and commends it to the House.